One of the mottos of the Virginia Education Association is, "What's good for the teachers is ultimately good for the kids." True or false? Today, education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society. It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to cultural values, in preparing him for later professional training, and in helping him to adjust normally to his environment. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. It would not be surprising to discover that these words are not familiar to even the majority that broke records in voting in November in the Commonwealth of Virginia. But these words, described as dicta by an attorney or one versed in the study of law, were the words written by Chief Justice Earl Warren on May 17, 1954, in the landmark Supreme Court decision of Brown v. Board of Education of Topeka, Kansas. And Dorothy, upon evidence presented by every veritable fact, we are not in Kansas anymore, because school is essentially closed, deemed for all intents and purposes a non-essential social gathering like weekly devotional worship in the church and family gatherings during the holidays, even by the nation's only physician serving as a state governor. By serendipity or providence, I found myself engaged in rigorous scholastic research on two institutions, devotional worship and classroom instruction, during the time of the emergence of a novel coronavirus in the central mainland of China, both of which institutions have incurred a direct injury by public health policy, upon which I had also been engaged with local pastors, particularly black Protestant pastors, involving a legal avenue of intervention through what appeared to be characterized as a heretical notion of adoption, and upon a jurisprudential notion that had evolved in the courts since the time of my early childhood on the issue which has been described popularly, at least, as a woman's choice, but which, at least jurisprudentially, has turned upon the question brought to the court by an intervener in litigation, a licensed physician whose name is forgotten, James Hubert Halford, who had alleged that statutes enacted by the Texas legislature had violated his own and his patient's rights to privacy in the doctor-patient relationship, and his own right to practice medicine, rights he claimed were guaranteed by the First, Fourth, Fifth, Ninth, and 14th Amendments, and the Supreme Court granted him leave to intervene. It is of note that the final opinion was sanitized by the severing of the intervening physician's complaint by dismissal, but went on to state that this holding, we feel, is consistent with the relative weights of the respective interests involved, with the lessons and examples of medical and legal history, with the lenity of the common law, and with the demands of the profound problems of the present day. The decision leaves the state free to place increasing restrictions on abortion as the period of pregnancy lengthens, so long as those restrictions are tailored to the recognized state interest. The decision vindicates the right of the physician to administer medical treatment according to his professional judgment up to the point where important state interests provide compelling justifications for intervention. Up to those points, the abortion decision in all its aspects is inherently and primarily a medical decision, and basic responsibility for it must rest with the physician. If an individual practitioner abuses the privilege of exercising proper medical judgment, the usual remedies, judicial and interprofessional, are available. And so in the end, although promoted as a right of a woman to choose in reproductive decisions, it was at least the view of the majority in Roe v. Wade that the abortion decision in all its aspects is inherently and primarily a medical decision, and basic responsibility for it must rest with the physician. And accordingly, it should not be surprising to find that the nation's only physician serving as a state governor, who has closed the schools, might have only a year before a pandemic crisis emerged as the national poster child for advocacy of a woman's right to choose infanticide for the infant to whom she gave birth. And yet again, by serendipity or providence, or even by grace of an uncommon luck, I had been advancing a proposition for publication in a scholastic journal to discuss a novel theory regarding the intersection of that assortment of outputs that the Brown decision had endorsed, at least in dicta, and its intersection with an achievement gap that has vexed communities of color, even in the best public schools in the Commonwealth of Virginia, around the same time that a novel coronavirus was beginning to change the face of our nation. An issue of first impression in any American court, and born in my experience in products liability law, that of those injuries incurred by plaintiffs under a theory of patent defect, but apparently an issue in which even the NAACP, marketed as the nation's oldest and boldest civil rights organization, expressed absolutely no interest, albeit not surprisingly, after their peculiar decision to announce a moratorium on public charter schools, the only solution that has presented any promise on addressing an achievement gap over 150 years old, and as old as the grants of freedom celebrated in emancipation from slavery, for which now even the state has accorded a paid holiday for state employees, albeit celebrating the achievement on the wrong day and the wrong signature event, focusing on Juneteenth and the announcement of the Emancipation Proclamation in Texas, which extended only to those states in rebellion, and not the 13th Amendment adoption in December 1865, which abolished the peculiar institution of slavery, even in the 5 slave states that chose to fight with the Union forces. But for parents unlike Kathy L. Tran, a survivor of refugee camps, who has embraced Governor Northam's promotion for infanticide, or Cynthia Boyd, a woman of color in Ohio, who has promoted the rights of mothers of children of color to be exempt from legislation intended to extend the protections of life to infants in the womb with a detectable heartbeat. Those sanctioned outputs of education that were recognized by the nation's highest court in the landmark Brown decision are of great significance in the advocacy supporting the reopening of our public schools to prevent our children from becoming defective products, unable to secure those blessings of liberty in the future, required in the performance of our most basic public responsibilities, even service in the armed forces, the very foundations of good citizenship, the principal instrument in awakening the child to cultural values, in preparing him or her for later professional training, and in helping her or him to adjust normally to his or her environment. At the end of what, for some, has been described as a pipeline to prison. As in these days, it is doubtful, very doubtful, that any child may reasonably be expected to succeed in life if he or she is denied the opportunity of an education. When used properly on a showing of preponderance of evidence amounting to more than an iota, in a statement of a legal cause of action upon which relief can be granted by a court deciding the case on the merits, an attorney can inform you that a patent defect is only that defect that is caused by the manufacturer and that is known or discernible by reasonable inspection. This, intriguingly, was a proposition that was stated in the matter involving Yeshiva University versus Fidelity and Deposit Company, which arose in 1986 in the courts of the state of New York. Moreover, as stated in Porto Venezia Condo Association, Inc. versus WB Fort Lauderdale, LLC, a federal case that was presented in the state of Florida in 2013. In a product liability case, a manufacturer may be held only liable for work that they completed for patent defects of which they were aware and for breach of any express warranties such as manufacturer may. Nonetheless, there are exceptions to this general rule, such as was held in Part v. Franco-American Trading Company, a New York State court case dating back to 1890, which had concluded that defective performance may be waived subject to the right of the party damnified to recover or recoup damages for loss he has sustained by reason of it, as might arise in what is termed an accord and satisfaction case. Essentially, under the doctrine of accord and satisfaction, the complaining party waives a right to recoupment on the ground that a judgment has already been satisfied. And there is considerable jurisprudence to support the proposition that simple acquiescence is sufficient. Similarly, those familiar with purchasing items, perhaps in a thrift store, on an as-is basis, assume the risk and agree to take the property with any and all latent and patent defects, under the express understanding that there are no express or implied warranties, including specifically that there is no warranty by seller that the property is fit for a particular purpose. My boy went to college. Doesn't mean that he has to graduate. As was stated in Texas cases of Chesson v. Hall in 2007, quoting the 1995 case of Prudential Insurance Company of America versus Jefferson Associates, Ltd. Nonetheless, in a normal arm's-length transaction, phrase you often find in the law, performed in good faith reliance, the controlling rule is clear that when faced with a patent defect, the offeror is obligated to bring the situation to the offeree's attention if he intends subsequently to resolve the issue in his own favor, as stated in Weston Beam Joint Venture versus U.S., a federal circuit case in the nation's capital in 2016. A theory for an affirmative defense that arises from the due diligence of the defendant to provide proper notice, like essentially stating that there were no refunds, no returns until the property was acquired by your informed decision, and just ask your mama, you are grown. For review, the governor has closed your school. You have been informed that there is an adverse impact to your children, and regardless of contributing circumstances regarding an unprecedented once-in-a-lifetime pandemic, you accepted that decision and the associated opportunity cost as a consenting adult, a parent or custodian of a child, withstanding to have brought suit, just like Oliver Brown did on behalf of his child Linda, when he decided to object to her having to walk or be bused to a segregated school further away from the perfectly good school for white children located closer to her home. And in that landmark decision, the highest court in the land stated, we come then to the question presented, does segregation of children in public schools solely on the basis of race Even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities. We believe that it does. Many arguments have been advanced, not surprisingly, by educators, sounding in compassion, but also providing all parents and custodians proper notice in due diligence that the absence of class instruction deprives a child of necessary social interaction. And certainly, although soothing to the ear and to the heart, the attorneys for the schools are aware that these alleged injuries amount to no more than speculative damages, neither personal nor direct, to the child of a parent or custodian, and that courts traditionally eschew speculative damages that lack a showing of a direct and proximate cause to a specific complaining party or plaintiff in a civil case. If your child is the next Enrico Fermi, he can forget it because he will need lab science instruction as a prerequisite before he gets into a good science and technology college. If your child is the next Roger Staubach or was relying on that athletic scholarship to get him further, it may be a good time to go into team huddle because your quarterback is out for the season indefinitely. If your child is the next Barbra Streisand, the greatest star by far, and nobody knows it, nobody is going to know it because at most schools you only have 2 opportunities to survive the auditions, to get to perform on the stage, to put on the resume, to get into that performing arts school. And that is a direct and personal injury in verified fact, neither indirect nor in speculation. Reviewing similar facts in the matter of Hill v. Woodard, decided in 1884, the Virginia Supreme Court wrote, by her conduct, as disclosed by the record, the appellant is stopped from questioning the verity of the record. Her evident knowledge of the pendency of this suit and its object, her seeming acquiescence, and her delay and refusal to speak, though not served with notice in the regular way, makes it proper for her to remain silent now that others have acquired rights while she was standing by in silence, if not in actual acquiescence. It was not only competent for her to speak in time and be made a party if she had not been, but it was her duty. Similarly, many commentators, including Barry Polvick, have attributed to Robert F. Kennedy the following phrase: if not us, who? If not now, when? While the dirge in tribute to his legacy sings of Abraham, Martin, and John, but concludes with the line, has anybody seen my old friend Bobby? Can you tell me where he's gone? And the sad, somber reply states that I thought I saw him walking up over the hill with Abraham, Martin, and John. My name is Major Mike Webb, and by God, I am running for governor of Virginia. I ask every Christian, every conservative, every Republican, every Virginian, and every American to, like the motto of the infantry, follow me, and we shall overcome. Honest. And y'all come back now. Yeah. advertisement was authorized by Mike Webb.